We are proceeding, Your Worship. I'm waiting for the...
Are you calling which case?
Your Worship, we're proceeding with the bail application. Correct, Your Worship.
Kenny. Where's my Pieter 21? I need Pieter 21. May I proceed, Your Worship? Please continue, ma'am.
As the court pleases, Your Worship, today is the 1st of October 2019, case number B552 of 19, State versus Esther, Tharina Human, and Laetitia Nell, and Pieter Jacobus van Sale. Your Worship, appearances are as before. Your Worship, this matter was postponed for applicant's case, Your Worship. As the court pleases.
Okay, Ms. Hester Tharina Human, Ms. Laetitia Nell, and Mr. Pieter Jacobus van Zel. You all three are comfortable to proceed in English, correct? All right, thank you. You can take a seat. Mr. May for number 1.
As it pleases the court, Your Worship. Your Worship, the first applicant is going to rely on a sworn affidavit in support of her bail application, and for that reason we have prepared an affidavit in support of the bail application for the first applicant. I'm in possession of the original signed and commissioned affidavit, Your Worship. To make it easy for the court to follow, can I hand up this up in the meantime before I read it out into the record?
All right, you can read it into the record, sir, and then hand.
Thank you, Worship. In the Magistrate's Court for the District of Amy'Leigh held at Vanderbijlpark, case number B552/19, in the matter between Hester Tharina Human, the applicant, and the state, the respondent, affidavit in support of the bail application. I, the undersigned, Hester Tharina Human, do hereby declare under oath as follows. 1.1. I am the applicant in the above mentioned application, an adult female aged 27, with the following personal particulars and background. 1.2. I'm a South African citizen, born on the 14th of February 1992, and with identification number 9202140146-088. 1.3. I do not possess a travel document. 1.4. I have never traveled to foreign countries and do not possess any assets in foreign countries. 1.5. I have relatives resident outside the Republic of South Africa, namely my mother's sister, Anna-Marie Kuleman, whom is married to Ronnie Kuleman. They reside in Australia for the past year. 2. Personal background. 2.1. I was born in Vereniging on the 14th of February 1992, 2.2. My highest scholastic achievement is grade 12, which I obtained in 2010 at Transvalia Secondary School, Vanderbijlpark. 2.3. After school, I did not obtain any tertiary or other training. 3. Current status, 3.1. I have one minor child born out of the wedlock. My minor child is Aresta Botha, aged 8 years, 3.2. I am currently married to Rudy Human, but is in the process of a divorce, 3.3. My address until my arrest on the 4th of September 2019 was number 12 Montefiore Small Holdings, Vanderbijlpark. I was residing there for 4 months. Previously, I have resided with my father, Rian Botha, at Epner on Waal, number 12, Lochval, Vanderbijlpark, for approximately 1 year. Prior to that, I've resided in Rustenburg. My biological mother, Christa Stolz, and her husband, Gawie Stolz, are residing at number 224, Kaalplatz, Vanderbijlpark. Since the arrest, my mother have moved my property to their premises. My minor daughter is also residing with my biological mother and stepfather since my arrest. 3.4. I was employed as a grade RR teacher at College Park Primary School in Vanderbijlpark for the past 8 months up until my arrest on the 4th of September 2019. Due to this matter before court, I was suspended. On the 19th of September 2019, at Vanderbijlpark Magistrate's Court, I was requested to resign as a teacher at College Park Primary School, which I did. I am since my arrest in custody at Johannesburg Female Prison. I will attempt to further studies through UNISA in 2020. 3.5. My gross income whilst teaching was 8,500 Rand per month, and my net income was 8,000 Rand per month. 3.6. I have the following assets. 3.6.1. Furniture to the value of 20,000 Rand. 3.6.2. A 2005 model Nissan Micra motor vehicle, which is still under hire purchase to the value of approximately 80,000 Rand. I have 10,000 Rand available for bail. My family has succeeded to borrow the money from family and friends, and we are liable to pay the money back. 4. History and antisocial behavior, 4.1. I have no previous convictions and or any other pending cases against me. 5. Arrest and factual background thereto. 5.1. I was arrested in this matter on the 4th of September 2019 for kidnapping and extortion. 5.2. I intend to plead not guilty to the charges. 6. Submissions regarding factors to be considered when deciding whether bail should be granted. 6.1. Considerations for bail in terms of Section 60, Subsection 4, Sub A to Sub E of the Criminal Procedure Act 51 of 1977. 6.1.1 with reference to Section 60, Subsection 4, Subsection A. I submit that there will be no danger to the public or my individual safety if bail is granted to me. It is my humble submission that the fears of the investigating officer is no proof that I will be a danger to public safety or my individual safety. 6.1.2 with reference to Section 60, Subsection 4, Subsection B. I submit that there is no likelihood of evasion of the trial, and I will attend all court proceedings as ordered by the Honourable Court. The court can also consider and impose bail conditions to ensure that I will stand my trial. It is my humble submission that the state did not prove that there is a likelihood that I will evade my trial. The state's opposition is based on the unfounded fears of the investigating officer. 6.1.3 with reference to Section 60, Subsection 4, Subsection C. I submit that I will not interfere with witnesses or evidence if bail is granted. In this regard, and according to the testimony of the investigating officer, there is only formal evidence outstanding. All other witnesses have already provided sworn affidavits and indicated that they are willing to testify. 614, with reference to Section 60, Subsection 4, Subsection D, I submit that there will be no jeopardy to the functioning of the criminal justice system or bail system if bail is granted. It is my humble submission that the state did not prove at all and or on a balance of probabilities that there will be a jeopardy to the functioning of the criminal justice system or bail system. 615, with reference to Section 60, Subsection 4, Subsection E. I submit that there is no circumstances which may lead to the undermining of the public order or peace, and I humbly submit that the state did not succeed to prove so. On the first day, 19 September 2019, of the bail application, there was a group of people who raised their voice against women and child abuse. And on the second day of the bail application, 20 September 2019, there was no one except the public that was interested in this matter. 616. The following other relevant factors can be considered by the court. 6.1.6.1. I will adhere to any bail conditions that the court might set. 7. In the premises and taking into consideration the relevant schedule the charges resort under, I respectfully submit that the court should grant bail to me in an appropriate amount and with such conditions attached as the court may deem fit. Your Worship, this affidavit was signed at today's date at Vanderbijlpark by the applicant, and it was also commissioned here at the police cells. I beg you to have this affidavit up as an exhibit, Your Worship.
Ms. Human, do you confirm the contents of this affidavit which was read in the record?
I do, Your Honor.
And you confirm that the signature on this affidavit under deponent is your signature?
I do, sir.
Thank you. The affidavit is then accepted and marked into evidence as Exhibit B.
Is it pleases the court, Your Worship?
Thank you, sir.
As it pleases the court, Your Worship, that is the application for the first applicant, Your Worship.
Thank you, sir.
Thank you, Your Worship.
Mr. Venter.
Thank you, Your Worship. Accused number 2 will similarly rely on an affidavit that has been prepared and which I, with leave of the court, will read into the record.
Yes, please continue, sir.
In the Magistrate Court for the District of Amy'Leigh held at Vanderbijlpark, case number B552 of 19, in the matter between the State versus Laetitia Nell, which is accused number 2 and the applicant in this matter, I, the undersigned Laetitia Nell, declare under oath as follows. I am an adult female and a South African citizen with identity number 79020500788088. I am the applicant in this application in which I seek relief from this honourable court to be released on bail pending the trial. I respectfully submit that the interest of justice permit my release on bail in any event. The dictates of fairness and justice in view of the peculiar facts herein warrant that I should not be deprived of my liberty and that I should be released on bail. 4. I make this affidavit voluntary out of my own free will and have not in any way been influenced to depose thereto. 5. The facts herein contained, save where expressly indicated to the contrary, are within my personal knowledge and belief and are both true and correct. 6. The purpose of this affidavit is to provide the Honourable Court with my personal circumstances and to as well address the factors to be considered by the above Honourable Court as contained in Section 60 in brackets 4 to 60 in brackets 9 of the Criminal Procedure Act. Personal circumstances. 1. I am 40 years old, divorced woman, residing at plot 28 Rosashof, Vanderbijlpark. I was born on the 5th of February 1979 at Welkom. I have resided in the Republic of South Africa all my life. I do not hold a South African passport or a passport of any other country. I regard South Africa as my permanent place of residence. More specifically, plot 28 Rosashof, I have no intention to relocate. 3. I am the owner of plot 28 Rosashof. This is an agricultural holding with a workshop erected on it, which I rented out. I am living from the rental received from this property as well as the maintenance I received from my ex-husband in respect of the 2 minor children. My 2 minor children resided with me prior to my arrest in this matter and are currently living with their father in Pretoria. The value of the plot is approximately 1.7 million rand. 6. I own movable assets comprised of household furniture and effects and a motor vehicle to the value of approximately 350 to 400,000 rand. All my friends and family reside in the Republic of South Africa and I do not have any friends abroad. 8. From the rental, I am currently receiving a monthly income of 10,000 rand. I am not disclosing the income in respect of maintenance as I accept that as long as the children are with my ex-husband, I will not receive any further payments in respect of maintenance. My son is 14 years old and my daughter is 10 years old. 9. I am in the financial position to pay bail. I have sufficient funds available to pay any reasonable amount set by this honourable court as bail. 10. I have never been convicted of any criminal offence before. There are currently no other outstanding cases being investigated against me by the South African Police Services. 11. I am looking after my father who is confined to a wheelchair. The merits. I have been informed that I am accused of kidnapping and extortion. 12. I am advised that I do not have to deal with the merits of the case for purposes of the bail application. Flight risk. 13. I will stand my trial should it proceed against me. There is no possibility that I will even think of not standing my trial. I trust the South African legal system. I own fixed property and my children, family and friends resides in South Africa. 14. There is no likelihood that I would interfere with the further investigation of this matter or with any of the witnesses. 15. I bear no grudges against anyone. And as stated above, I do not have any previous convictions. 16. I am aware of allegations on social media that my bags were packed and I was ready to flee to an undisclosed destination just prior to my arrest. I deny these allegations as they are devoid of truth. I humbly and respectfully submit that the facts as set out above support my contention that I do not constitute a flight risk. I humbly submit that my continued incarceration can only prejudice me and create no benefit to the state. I further humbly and respectfully submit that should I be released on bail, my release shall not disturb the public order or undermine the proper functioning of the criminal system. 20. I will comply with any conditions set by the above honourable court. 21. I accordingly submit that the interest of justice, consideration of prejudice, and the balancing of respective interests favour my release on bail. Dated at Vanderbijlpark on this 19th day of September 2019 and signed by Laetitia and the Commissioner of Oath.
Thank you, sir. Right, Ms. Nell, do you confirm the contents of this affidavit?
Yes.
Ma'am, and do you confirm that the signature on this affidavit under Laetitia Nell is your signature? Right, the affidavit and the statement is then accepted and marked as Exhibit C.
As the court pleases, Your Worship, that concludes the case for applicant number 2.
Thank you, sir. Mr. Chirwan.
Thank you, Your Worship. Firstly, I confirm, Your Worship, that this bail application falls in the ambit of a Schedule 1 bail application, Your Worship. And applicant number 3, Your Worship, has opted to also bring his application by way of sworn affidavit, Your Worship. With leave of the court, may I read same into the record?
Yes, please do.
As the court pleases. In the Magistrate's Court for the District of Amy'Leigh held at Vanderbijlpark, case number B552 of 19, in the matter between Mr. B. Jacobus who is applicant number 3 in this matter, versus the state, who shall be the respondent. Affidavit in support of bail application, I, the undersigned Pete Jacobus hereby state under oath, I am applicant number 3 in this matter, and the facts deposed herein are within my personal knowledge both true and correct. I am a male South African citizen, and my date of birth is the 22nd of June 1969, and therefore that would make me 50 years old of age. I do possess a valid identity document. I do not have a passport, as I've never traveled abroad, and therefore do not have family ties outside the Republic of South Africa. My residential address used to be number 24 Rosasov, Small Holdings in Vanderbijlpark, where I stayed there with my wife for about 10 years. Around February 2019, I instituted proceedings to sell that property, and the transfer of that property only went through on the 5th of September 2019, subsequent to my arrest in this matter. My wife then moved in with my daughter, one Miss Johandri Vansay, who stays at number 46 Jeffrey Farnell Street, SW1 in Vanderbijlpark, and I've been informed by her that I'm welcome to stay with them up until such a time where I get my affairs in order. I therefore submit to this honorable court that the above mentioned address at number 46 Jeffrey Farnell Street in Vanderbijlpark shall be my residential address, where I will stay with my wife and my daughter and her family. Should the court require an alternative address, I humbly submit that my friend Elise Pieter, residing at plot number 2 Rosasov, Small Holdings, Vanderbijlpark, has informed me that I am welcome to stay with her. As submitted above, I am married with one dependent being my daughter, who I shall be staying with. I no longer own any fixed assets due to the reasons advanced above. At the present moment, I am currently unemployed. My legal representative has fully advised me of the legal consequences of not complying with the provisions of Section 611B of the Criminal Procedure Act 51 of 1977. As submitted on my first appearance in court, I have one previous conviction of theft in 2005, and I do not have any other pending matters. I am aware of the charge that is leveled against me, and it falls within the ambit of a Schedule 1 bail application. My legal representative has further explained to me my right to remain silent and the right to not incriminate myself, and that whatever I say in my bail application may be used in my subsequent trial. I would further like to state that I will be pleading not guilty to the charge against me, and hereby inform the court that my release on bail will be justified and that the interests of justice permit. And further would like to bring to the attention of the court that I am not a flight risk, and the fact that the sale of my property went through around the same time as my arrest is only but a coincidence. As I have mentioned, I need to get my affairs in order, and therefore my continued incarceration hinders me from doing so. I am of a relatively senior age and therefore have no means to evade my trial. I will attend to my matter until finalization. I would like to state further that I will comply with Section 64A to E of the Criminal Procedure Act 51 of 1977, and that I will not endanger the safety of the public or any person. I will not evade my trials, as I do not have the reason to abscond, as I am not guilty. I will not intimidate witnesses and or destroy evidence, as I do not know the evidence that is in the state's possession. My release on bail will not undermine the proper function of the justice system or undermine public peace, as I do not have the means or power to cause any harm to anyone. Should I be admitted to bail, I can raise an amount of 1,000 rands for my bail. I have no objection if the court subjects my release on bail to certain conditions. I humbly submit that the Honorable Court admits me to bail, as there are no justifiable reasons why I should be kept in custody. I know and understand the contents of this affidavit. I have no objection in taking the prescribed oath. I do consider the prescribed oath binding on my conscience. Signed by the applicant, dated at Vanderbijlpark on this first day of October 2019, duly commissioned here in Vanderbijlpark. Your Worship, with leave of the court, may I hand in same as an exhibit? As it pleases the court, Your Worship, that shall also be the case for applicant number 3, this bail application. Court pleases.
But Mr. Chirwa, this affidavit does not have the required stamp. Neither do we know who the person who commissioned the affidavit is.
Your Worship, may let me understand that from the deputy.
Can we, will 10 minutes be sufficient?
It will be sufficient, Your Worship.
The court will then adjourn for 10 minutes. Okay, we are back on record in the matter. Ms. Human, Ms. Nell, and Mr. Vanzel, you can take a seat and be seated. Mr. Chirwa, have you remedied the affidavit?
Indeed, so, Your Worship, it has been remedied. In behalf of the court, may I hand in say?
Please do.
As the court pleases, we should go indebted to the court.
Right, Mr. Vanzel, do you confirm the contents of this affidavit which was read into the record, sir? Do you confirm that the signature on this affidavit under applicant is your signature?
Yes.
Right. The affidavit is then accepted and marked as Exhibit D. Thank you. Ms. Ngobo.
As the court pleases, Your Worship, the state will request the adjournment, Your Worship, to prepare the arguments in this matter, Your Worship.
All right. Is the state ready to proceed with arguments then today?
Your Worship, not at this stage. Hence, the state is requesting an adjournment, Your Worship, to just finalize its preparation for the arguments, Your Worship.
Get your mind in order. Get the mind in order.
Correct, Your Worship, if I may put it like that.
Mr. May,
As it pleases the court, Your Worship, I'm ready to proceed with my argument.
I confirm that we are also ready to proceed, Your Worship.
thank you.
I wish to add that it's in the interest of the accused that this matter be handled as quickly as possible and finalized.
Yes. Mr. Chirwa,
Confirm, Your Worship, no objection. We are ready to proceed, Your Worship.
all
As the court pleases.
right. Ms. Ngobo, how long does the state require?
30 minutes, Your Worship.
All right, Ms. Ngobo, the court will then allow you 30 minutes to make or finalize the preparations for the closing arguments in the matter. Perhaps maybe we can break at the same time for a tea break, and then we can continue from there. And with the closing arguments in the matter from both the state as well as for the applicants, and perhaps maybe we can conclude the matter.
Correct, Your Worship.
As the court pleases, Your Worship.
The court will adjourn. We'll resume again at 10:45.
Because how? Because now it's...
You can't drink tea and prepare.
I can't eat and prepare.
We are back on record in the matter. Ms. Ngobo, is the state ready to proceed now?
Correct, Your Worship. The state is ready to
Right, you
proceed.
may proceed, ma'am.
As the court pleases, Your Worship. Your Worship, this is a formal bail application, and it is a Schedule 1 offence, Your Worship. And all three accused in this matter are charged with kidnapping of a child or a minor of 6-year-old girl, and extortion and ransom, demand of ransom of 2 million rand in this matter, Your Worship. Your Worship, the state, the onus rests on the state to satisfy the court that it is, or the interest of justice, do not permit the release of the accused before this court, Your Worship. Your Worship, the state will indicate that it has a very strong case against all three accused, Your Worship. Firstly, Your Worship, the accused, there are witnesses who are going to come and testify against the accused in a trial matter, Your Worship, wherein one of the witnesses will come and testify that she or he was there when this plan was made by the accused before court, that the accused number one, Your Worship, is the mastermind of everything in this matter, Your Worship. She was the one who came with the ideas as to what should happen on the day in question. Actually, she firstly offered herself as the victim, that she should be the one to be kidnapped, Your Worship. Seeing that it's not going to be successful, she offered her sister-in-law, who is a relative to her. Your Worship, the state will also want to clarify that, as the investigating officer indicated that that witness is a close family member of accused number one. Your Worship, according to Africans, if I may put it like that, we believe that a mother, a father, a daughter, a son, or children, if I may put it like that, and aunts, in-laws, cousins, they are a family, a close family, Your Worship. But with white people, Your Worship, they believe that a family or a close family member is a mother, father, and children. But according to us, Your Worship, everybody, or the aunts and the cousins and the in-laws, are the family, close family members, Your Worship. Hence, the investigating officer was saying in his testimony that the witness, that is the sister-in-law of the accused number one, is a close family member of accused number one, Your Worship. Then the witnesses will also testify that they were there when these witnesses, the witness will come and testify that she was there when they planned this, that she's going to offer herself, offer the sister-in-law. They even tried, Your Worship, to execute their plan by trying to kidnap accused, the second victim, that is the sister-in-law of accused number one, but, Your Worship, with no success. Without that telephone made to the sister-in-law of accused number one, we wouldn't be here today, because it's the one evidence that led the police officers to accuse number two twice, Your Worship. Hence, we were able to arrest all three accused before this court, Your Worship. And furthermore, Your Worship, there's a witness that will come also and testify that she was there when accused number three, Your Worship, brought the victim, the 6-year-old girl, Your Worship, into his house, Your Worship, on the day of this incident. And she saw them with the fourth accused in this matter that has already been arrested and is appearing in a court, Your Worship. The witness indicated that he saw them bringing that child in his house, Your Worship. And there's another witness, Your Worship, and the state also, Your Worship, has evidence against the accused. that of the telephone records that shows that the accused are linked into this matter, Your Worship. And furthermore, Your Worship, the accused before court, when the police officers were following the investigations to accused number one's house on the day of this incident, in the early hours of the morning, accused number 1, 2, and 3 were in the same house of accused number 2. Your Worship, the court in the trial matter will have to draw an inference as to what they were doing in the early hours of the morning in accused number 1's house, together with the very same motor vehicle, the Toyota Fortuner, Your Worship, the white Toyota Fortuner, that belongs to accused number 2 in the very same house, Your Worship. That is the state evidence, Your Worship. The state believes that it has a strong case against the three accused, Your Worship. Therefore, Your Worship, there is also a pointing out that was made by the accused applicant number 3, Your Worship, of the cell phone that was used to demand the ransom from the family of the victim, Your Worship.
Sorry, Ms. Ngobo, what you say, the pointing out?
The pointing out of the cell phone that was used when they demanded the ransom, Your Worship, from the victim's parents, Your Worship. That pointing out was made, Your Worship, and Your Worship, it will be part of the evidence that the state is going to use against the accused before court, Your Worship. Accused number 2 has made a confession, Your Worship, to a magistrate in this very same court, Vanderbijlpark court, where in her confession, Your Worship, she implicated accused number 1 and accused number 3, Your Worship. The state believes that it has a strong case against all 3 accused before court, Your Worship. As it was also indicated or put by the investigating officer in this matter to say that we're still going to do some investigations, especially after we received the records that we are awaiting on the state further believes that there is a likelihood, as it was put by my investigating officer, that there's a possibility, in simple terms of likelihood, Your Worship, that there's a possibility that the accused before court will endanger the safety of the public or any person, Your Worship. The state is saying that because, Your Worship, the accused before court, accused number 1, offered herself, Your Worship, to be kidnapped. She offered a sister-in-law to be kidnapped. She even offered a child, Your Worship, a 6-year-old child, Your Worship. What will stop them from committing another one, Your Worship, from committing another offense or committing the very same offense or endangering somebody else, Your Worship? The court must remember that there's an allegation that the reason we are here today, according to accused number 1, she wanted money to pay the Nigerians, as according to her, she has a problem with drugs. She's a drug addict, if I may put it like that, which was not even disputed, Your Worship. If the accused number 1 is a drug addict and the Nigerian out there is not paid, Your Worship, his money, if they are released, Your Worship, whose child is going to be a victim? Which woman is going to be a victim this time around, Your Worship? Because this Nigerian guy, Your Worship, is still waiting for his money. That debt is still outstanding. It's not paid. He wants his money. It's not about that money, I believe, Your Worship, now. It's also about him being exposed on television. I believe everybody is watching this. Everybody knows and follows as to what is going to happen with this case. Same, I believe, applies with the Nigerian guy, Your Worship. I believe he wants his money. He's angry that he has been exposed. Anything can happen, not only to the victims out there, but also to the accused, Your Worship. Her safety, the safety of the other two accused, Your Worship, is at danger. Hence, the state is saying that they are going to endanger the public and also themselves if they're out there, because anything can happen to them. They also made an application, accused number 1 and 2 on a previous occasion, Your Worship, made an application in an affidavit saying that they were threatened by the public, by the inmates or the offenders in custody where they are kept, Your Worship. If an inmate, somebody who is in custody, who committed also an offense, Your Worship, threatens somebody else, believes that what he or she has done is better than what they have done. What about the public out there, Your Worship? The innocent people who want to protect their kids, who want to protect their wives, Your Worship. What will happen with the accused if they are released on bail, Your Worship? Then the state will also look at the fact of Section 4, Subsection B of 60 Subsection 4, 64 Subsection B, Your Worship, that according to the state, it believes that there's a possibility that they will evade, Your Worship, their trial. Reason being that accused number 1, she doesn't have any property, movable property. She was renting where she was staying. According to the investigating officer, she told the investigating officer that she doesn't own anything. She went into that house with her own clothes. She doesn't own any property there. She doesn't own any furniture. That was never disputed. She didn't come to court, to the witness box to say, I didn't say that, I own this and that and that. She only made it in an affidavit, Your Worship. The defense didn't give the state an opportunity to test the credibility of the applicant number 1, Your Worship. She has a child, Your Worship. The child is now permanently in the custody of the mother of applicant number 1, Your Worship. The state is saying, what is it that will keep accused or applicant number 1 here or make her come and attend this trial if there's nothing that will stop her from evading it? There's nothing, Your Worship, on the table that will say, okay, this is what I have, I cannot go here, I have a child, I'm staying with this child is safe with the parents. The child was taken from the accused or from the applicant number 1 after she has committed this offense. She doesn't have anything, Your Worship, against her, or that she has that she will use and say that I am going to, I'm not going to leave this country, or I'm not going to go anywhere because I have this, or this property, or a child for that matter, Your Worship. Then accused number 2, or applicant number 2. Applicant number 2, Your Worship, she indicated to the investigating officer that she owns a plot. She doesn't own any plot. She's staying there with the parents. It belongs to the parents. Now she's coming today with her affidavit also, Your Worship. She didn't come to the box, Your Worship, to be tested, her credibility, as she indicated, Your Worship, that she is now owning that plot, Your Worship. According to the state's investigation, this very same plot is on sale, Your Worship. It can be sold at any stage. And even if you can go and check and Google it, Your Worship, it's still on market to the value of 850,000, Your Worship. She doesn't have any property. She's not unemployed, as well as accused number 1. She's unemployed. She was working as a teacher, but she's not unemployed. Accused number 3, or applicant number 3, he's also unemployed. He doesn't have any property. He has sold his plot, Your Worship, that he had. Now he doesn't have any property. Now he comes with his affidavit and saying that my daughter is saying is going to stay with me. Even the daughter, it's not the property of the daughter, Your Worship. It's the property of the in-laws of the daughter. The in-laws of the daughter didn't come and say, Your Worship, I'm here, I'm available, I'm going to take him and stay with him. They didn't come and say that. The only thing that we have is a document of an affidavit that says, my daughter is going to take me in. The investigating officer indicated that he went there. The owner of the house indicated that I do not want this man in my house. I'm staying with kids. But there's nothing that says accused number or applicant number 3 or that the owner of that house comes and says, okay, I am willing to take him back. Your Worship, it was also indicated that no, when the investigating officer was testifying, he indicated that they are not wanted. Their families are angry with them. It is normal, Your Worship, for the family to be angry. Yes, they are angry with them. It is normal to support their family. They cannot let them go. But that doesn't change the fact that they are angry with them. That doesn't change the fact that it is alleged that they have committed a serious offense like this offense, Your Worship. It will always be there. But yes, they are going to support them. But it doesn't mean that they want them back, Your Worship. The state will come to the seriousness of this offense. My learned colleague indicated that every case that comes to court is serious, Your Worship. The state agrees 100%. Each and every case that comes before this court is a serious offense. This is a Schedule 1 offense, Your Worship. We have it. I'll make an example. We have a Schedule 1 offense of an assault common where somebody is assaulted with an open hand. It's a serious offense before this court. We have this case where a child of 6 years, a 6-year-old child, girl, kidnapped, kept in a small room for about close to 24 hours in a filthy, dirty place, grabbed from the mother in front of other young, small kids, Your Worship, and an amount of 2 million rand was demanded from the parents of the accused. The difference is, that's why, Your Worship, in court, there are different jurisdictions of sentencing, and it depends on the seriousness of the matters. We cannot take a common assault matter into a regional court for sentencing, because in this very same case, a sentence of caution and discharge can be given. The suspended sentence can be given, but not a 15 years sentence, direct imprisonment, cannot be given in this case, Your Worship. Hence, this matter might be heard in a regional court and or in a high court, Your Worship, for a very serious sentence, Your Worship, of 15 up to a life sentence, Your Worship. Therefore, to see the difference of the seriousness of the case, the state is saying each and every case differs with its merits. The merits cannot be the same, though every case is serious before this court. The state is saying this matter is a very serious matter. Hence, today in this court, we are having a media, Your Worship. Everybody wants to know, as it has been a challenge in our country that children are being abused, children are being kidnapped, children are being raped, Your Worship. This is one of the cases that makes even the media to come and see what is happening, what will happen to this case, Your Worship. It shows the seriousness of the matter. They will not come and say, okay, somebody came and assaulted somebody with an open hand, Your Worship. I'll go to further given another example of a murder case, Your Worship. It can be a murder. Both cases are Schedule 5 offences. It's murder where one can be given a suspended sentence, and a murder where one will be given a 15-year upwards or even a life sentence, Your Worship. That shows the seriousness of the matter. It depends on the facts of the matter or merits of the matter, Your Worship. Therefore, the state still insists that it has a serious, this matter, it's a serious matter, and the state has a strong case against the accused before this court, Your Worship. The state will further go to the fact that it is a likelihood or a possibility that the accused before court can influence the witnesses in this matter. Your Worship, it's a sister-in-law. Should the accused go out there, indeed she will influence her not to come. Yes, at this stage she's willing. She has given a statement. She's willing to go and testify. But if she goes out there, she will go and influence her to say, no, you cannot testify against me. They are family, Your Worship. They are related somehow, Your Worship. The state witness, another state witness, the lady who saw accused number 3 or applicant number 3 with the one accused that has been arrested later, which was last week, Your Worship, saw them bringing this child. This very same person gave a statement. She's willing to testify, but should the accused before court go out there, definitely, Your Worship, he will intimidate him or her. He will influence her not to come and testify, Your Worship, in this matter. And the state will also indicate that even accused number 2 knows this witness, Your Worship. The witness is known to also to accused number 2. And there's this also witness, Your Worship, that will come and testify and say that I had them pre-planning this matter. This accused is known to accused number 3. Actually, all of them, Your Worship. They can go out there and influence this witness not to come and testify against them. What will stop them from doing it, Your Worship? They will do so, Your Worship. There's no need for the state to have evidence to say that this is the evidence. The section is saying if there's a likelihood, if there's a possibility that they will do it. The state is saying there's a possibility because they will go out there, they know them. And coming to the fact of the public, Your Worship. The camera says it all, Your Worship. The public wants to know what is happening. My learned colleague of the attorney who was representing the media indicated that the people out there want to know what is happening with this case because people are worried out there, Your Worship. They want to be protected from people like the accused before court, Your Worship. Their children, they are no longer feeling safe with their children, Your Worship. Remember, Your Worship, accused number 1 was a teacher to the victim. She was in the very same class of the victim. I consulted with the mother this morning. The schools the schools were reopened this morning, Your Worship, today. When she was supposed to go to school, they had to beg her. She was crying the whole night. They had to beg her to go back to school. When she comes there, they had to change the place where she was. They used to drop her. They had to take her to the teacher. Your Worship, she's frightened. She's traumatized. I'm also informed, Your Worship, that this very same child, the previous day, Your Worship, I was informed that she was sick. She was taken to the hospital. And she was diagnosed, Your Worship, of stomach ulcer. A 6-year-old, Your Worship. According to the doctor, it's because of all this, what had happened, Your Worship, that caused that. We are talking of a 6-year-old, Your Worship. On the 19th of September, when we started with this bail application, there were people from different organizations, Women's League, ANC, you name it, some from Pop Crew, police officers, women, males, all sorts of races, black, white, Your Worship, they were there fighting, saying no to this bail. One of them was even interviewed, Your Worship, I saw it on television. She was interviewed, she said, we are tired, we are saying no more, enough, it's enough, no more. We are tired of people abusing kids or abusing women. We are here to support the family of the victim. People are tired, Your Worship, of things that are happening in our country where kids are involved, Your Worship. They had to leave their jobs and come and show the court that we are against what the applicants before this court has done. Hence they were there shouting. The court must also remember that when this incident occurred, there were other kids who were dropped by the parents there. They could see what had happened, Your Worship. They were also traumatized by what had happened. Your Worship, these might be small kids of 6 years, 7 years, 9 years, Your Worship, but they know what is happening. As I was consulting with the mother of the accused this morning, she indicated that the accused, every time when they come back from court, she wants to know what had happened. What is happening to these people? Are they coming out, Mommy? Are they going to threaten me? Are they going to take me again? She's traumatized, Your Worship. When she heard that the fourth accused or suspect has been arrested, she was relieved and saying, at least they are all going to custody. But if the court, Your Worship, released these people, this poor child will always be worried and always be, I wonder she will want to go to school ever again. Because she's afraid of them. To show Your Worship that these people were, I don't know how to put it, Your Worship, but if I can say they are cruel. This child was kept in a dirty, small room. After that, Your Worship, she was dumped next to a pub around 2:30 in the morning, a 6-year-old girl. The safety of that child, Your Worship. What would have happened to her? That place is not only a pub, that is where drugs are sold. The safety of that child. They didn't even think of taking the child maybe next to McDonald's where it's 24/7 open, or next to the police station that is also 24/7 open for the safety of the child. But they were so cruel to leave the child where she doesn't even know where to go. She's 6 years old, Your Worship. She's a child. She's a child, a girl. And, Your Worship, when this child was grabbed, these people prepared their thing, they made it, Your Worship. When they planned to go and grab the child, they knew that it will be a woman who cannot be able to protect a child. Maybe if it was the father of the child, maybe he could have done something to protect the child, but it's a woman. She ended up being assaulted. She sustained injuries, Your Worship. But maybe if it was a male, if it was the father, maybe he could have done something. Maybe he could have fought for his child. The poor woman, the poor children who were there. Therefore, the state is saying, Your Worship, these kids, young as they are, they watch television, they want to know what is going to happen to these people. Your Worship, they believe and have their confidence in the court that the court will protect them from the people or from the applicants before this court. Women out there are depending or relying to this court to protect them by keeping the accused in custody. Parents of children are relying to this court to keep the accused in custody. Even I believe the teachers or the school, the principal, the teachers, and everybody in that school is relying to this court to keep these people in custody. The school is now exposed, Your Worship, of people. I believe the parents will never trust them anymore because of the accused, especially accused number 1 before this court, Your Worship. She was looking after this child. The parents gave their children to the people like the accused number 1, trusting them that they will take care of them. Where are we supposed to take our kids now? Your Worship, it is the state's submission that should they go out there, they will definitely endanger the people out there, and not only endanger or put other children in danger, also themselves. The state is saying they should be kept in custody for their safety and be there, Your Worship, because there they will be looked after. There will be police officers who will guard them, even if they are threatened, but they will be able to have a place where they will be safe. And further, the children out there will be safe. As the state has already indicated that the Nigerian is waiting out there, Your Worship, he wants his money. The money is not yet been paid. Therefore, the state will strongly request the court not to grant bail on all 3 applicants in this matter, as the court pleases.
Thank you, Ms. Ngobo. Mr. May.
Mr. Court, Your Worship. Your Worship, I will deal with the address of the state at the end of my address. The state is quite correct in the opening to state that the state is burdened with the onus to prove on the balance of probabilities whether the applicants should be granted bail. The question is, Your Worship, in my view, whether the state did succeed to prove this in this court that they have proof on the balance of probabilities that bail should be granted. And for the court to consider in this regard, the court should consider, Your Worship, and shall decide in terms of Section 60, Subsection 9 of the Criminal Procedure Act, Act 51 of 77, which reads as follows in the heading. In considering the question in Subsection 4, the court shall decide the matter by weighing the interest of justice against the right of the accused to his or her personal freedom, and in particular the prejudice he or she is likely to suffer if he or she were to be detained in custody, taking into account, where applicable, the following factors which is set out under Section 9, Subsection 9 of Section 60, Your Worship. Your Worship, the aspects for the court to consider whether bail should be granted or not is set out in Section 60, Subsection 4, Subsection A to E of the Criminal Procedure Act, and further respectively to be read with and in regards with subsection of Section 60, Subsection 5 to 8 of the Act, Your Worship. Now, with reference to the onus of proof, Your Worship, the State relied on the evidence of the investigating officer. My submission is, Your Worship, that the evidence of the investigating officer was based on fears created by himself and speculation, Your Worship. On numerous occasions, the investigating officer testified that they might, and there's a possibility, without giving any hard proof of why he testified to that effect. Your Worship, if I can deal with subsections of Section 64, Subsection A to E, my colleague referred to that the accused might endanger themselves or the public if the court will take in consideration the evidence of the investigating officer that there were three plans. First, the applicant number one offered herself, then she offered, or she threw, as the state argued, her sister-in-law, which is in fact the friend of her brother, who's the mother of her brother's child. And then lastly, she referred to the 6-year-old child, Your Worship, and which was in the class of the accused, or the applicant. Now, that was based on the evidence of the investigating officer, Your Worship, that this came to the fourth. There's a witness who's going to testify that he or she was present when this was planned. Now, the court will remember at the end of the cross-examination of the investigating officer, it was put to the investigating officer on the day before. He said there was two important witnesses, except for formal witnesses, who can testify with regard to this matter. He was also confronted later by applicant 2 and 3 about further witnesses. Even if there were 3 witnesses, Your Worship, the fact of the matter was, one of the witnesses that was indicated and identified by the investigating officer was as the state referred to, sister-in-law. In fact, the mother of the child of the applicant one's brother. Now, Your Worship, it was specifically put to the investigating officer that it was the instructions. That witness confirmed that she was confronted by the South African Police Services with reference to the identification of a telephone number which she could not identify. It was further put to the investigating officer, Your Worship, that witness is present at court, and with that, Your Worship, the applicant opened the door for the state to call on that witness to testify to the contrary, in effect to support the investigating officer's evidence that she was quite a very important witness to this matter, Your Worship. but it was not done. In my view, Your Worship, the court can make a negative inference of the fact that that witness was not called to confirm whether her evidence was only about the identification of a cell phone number, and it was blown up by the investigating officer how important she was. My question further to that, in that regard, Your Worship, if that is not done, can we really rely on the evidence of the investigating officer, what was done in court, if there's no support for that? And on the address of my learned colleague, Your Worship, she touched many aspects which was not evidence in this court. Aspects around the merits, which the state will prove in time to come when the matter is going on trial. That was not evidence during the bail application, Your Worship. That was aspects that was addressed now in the address that is going to be presented by the state in time to come. Your Worship, furthermore, the state is also relying on the fact that, and I do not dispute it, Your Worship, at this stage, in all fairness, but the state wants the court to take in consideration, and I sympathize with the family of the child, Your Worship. I really do sympathize with the family of the child. But the state requests the court to take into consideration certain aspects, like the child, who's a 6-year-old, has a stomach ulcer, Your Worship. The child wants to know every day when we were at court, what is the outcome? Are they still in custody? Is she still protected? The child does not want to go to school, is crying all the time, Your Worship. Your Worship, my respectful submission in this regard is that the state had the opportunity to call on the mother to come and testify that, for that evidence to be tested during cross-examination, and to establish whether it's true what the court has now, what the state has now conveyed to the court. Your Worship, to deal with the aspects that my colleague referred to, and specifically with reference to section 64A, whether if bail is granted, there will be a danger to the public or the individual safety. It's still my humble submission, Your Worship, that that is based on the fears of the investigating officer. There's nothing else brought before this court from the state, except for explanations, Your Worship, during address that they will be a danger to the public's or their own safety. Your Worship, for that reason, I request the court, and that is one of the aspects that the state relied on, and specifically that was confirmed by the investigating officer. He relied on section 64A, B, and C to oppose the bail when I started with my cross-examination, Your Worship. Your Worship, it's also my submission with reference to the second question that the court should look to is that will they attend bail, will they evade bail? The applicants, and now I refer to specifically applicant number 1, it was now argued before this court that because she has no property, or because she has no immovable property, and for that reason, and that the child is permanently put into the care of her mother, she has all the reason to flee. At this stage, Your Worship, I want to make it very clear, I will address the court on some case law, but amongst all the applicants, Your Worship, just to avoid repetition of reference to case law, myself, Mr. Venter and Mr. Chiwa will refer to case law, and I request the court to take all the case law in consideration when the court is considering whether bail should be granted. Now,
Mr. May, on that point, if you are going to rely on case authority, then you need to, and you must submit to the court a list of your stated cases.
I will do so, Your Worship. I will do it.
Obviously with the correct citation.
I will do that, Your Worship. I won't be able
This
to
makes
do
it easier then for the court to uplift and to verify those case authorities at a later stage. The court found in its experience that sometimes on argument, not by yourself, but in the experience of the court, that case authorities was relied upon, citations were given, And when the court went to go check on those authorities, it's nowhere to be found.
No, I've got no problem, Your Worship. I will support
All
same. Your Worship, but my request is where I refer to case authority or Mr. Venter or Mr. Chirwa, the request of the applicants is that for the court to take all the case law in consideration when considering whether bail should be granted or not.
That is fine.
Your Worship, the state referred to the strength of the state's case, and in this regard, she referred to aspects, Your Worship, which was not evidenced in this court during the bail application. But my learned colleague will specifically refer the court to the matter of, and we will prepare an index, Your Worship, the matter of Nell and others versus the state, 2018, Volume 1, SACR, South African Criminal Law Reports, page 576, GJ, 17 October 2016, which is very important in this regard, Your Worship, with reference to the strength of the state's case. I also want to refer the court in this regard, where there's a likelihood to evade the trial, to the following aspect, Your Worship, in State versus Vermaas, 1996, Volume 1, SACR, page 528, T. The learned Judge Van Dijkhorst referred to Section 60, Subsection 4, Subsection B, as the prime consideration. Sorry, that is the question whether the accused will stand his trial. I also refer the court to State versus Napoleon. It's an unreported matter. Reference ECG, case number CA&R 206/2015, delivered 20th of August 2015, where the learned Judge Pickering stated as follows at 51, emphasis in the original. The magistrate erred in his approach to the matter. The high water mark of this finding was that the strong prima facie case and the possibility of the appellant being in prison for a long time may provide a temptation to the applicants to evade their trial. This is not the test. As appears from subparagraph B, it must be established that there was a likelihood that the appellants would attempt to evade their trial. The word likelihood connotes something much more than a mere temptation. It is defined in the concise Oxford English Dictionary as meaning a probability. Your Worship, in making out it's a strong case, Your Worship, the state also referred the court to the seriousness of the crime and the sentences that can be imposed. Now, Your Worship, the charges against the applicants is one of first, kidnapping, which is a Schedule 1 offence, as well as extortion, the second offence. On the second offence of extortion, as was put by the state to the applicants, Your Worship, or that was disclosed to this court, the Act on Minimum Sentences, Act 105 of 1997, is applicable in the sense that where the amount that was claimed is more than 500,000, Your Worship, then there's for a first offender, you can be sentenced or you must be sentenced. The court is statutorily obliged to bring out a sentence of 15 years direct imprisonment, unless there is substantial and compelling circumstances. Your Worship, and that is for the trial court to hear. If there's if the applicant is found guilty of any offence, and especially extortion, then that court will establish whether there is compelling and substantial offences. But the Act provides for a first offender to be sentenced for 15 years unless that is present. With reference to the kidnapping, Your Worship, the jurisdiction of the courts or the trial court who's going to hear this, either the regional court or the High Court, Your Worship, they've got jurisdiction in terms of the Act, how they will sentence. But, Your Worship, then the court will also have to take in consideration the tried aspects of the seriousness of the crime, the interests of the society, Your Worship, as well as the personal circumstances of the accused. They should weigh that up evenly, Your Worship, and not overemphasize the one aspect against the other to reach a fair and reasonable sentence. They will also take that take sentence in consideration with the aims of sentence, Your Worship, which is deterrence, retribution, prevention, reform, and rehabilitation. Now, Your Worship, with reference to section 64C of the Act, that there's a possibility that the witnesses can interfere with the witnesses and or evidence, Your Worship, that is outstanding. The evidence of the investigating officer is before court that there's only formal evidence outstanding, firstly, and secondly, Your Worship, that the people who made statements and affidavits are also indicated that they're willing. The state called that they still will be influenced because they are known. It is a fact, Your Worship, I've already referred the court to this aspect, that one of the important witnesses, according to the state, that was identified was a close family member of the applicant number one, and it was put to this court what is the instructions, what she will testify about, and what she was confronted about. And it was never disputed by the state, and the state never called on that witness to come and say or testify to the contrary. Worship, with reference to section 60, subsection 4D of the Act, whether there will be a jeopardy to the functioning of the criminal justice system and the bail system if bail is granted. My submission, Your Worship, that was not a ground for opposing the bail, as indicated by the investigating officer, Your Worship. But even if it is a ground, there was no case made out or no proof of whatsoever through any witness, Your Worship, on a balance of probabilities that the applicant will jeopardize the functioning of the criminal justice system or the bail system if bail is granted. Also, with reference to subsection 4E, if there are circumstances which may lead to the undermining of the public order or peace, and Your Worship, my submission is that the argument of the state is that the protest that was held on the first day of the bail application, which was the 19th of September 2019, there was a protest against women and child abuse, Your Worship, which is in the order in this month and in the past few weeks, protest against women and child abuse, Your Worship. It happens to be held at this court, Your Worship, but I did not see any thing of the, in regards to the fact that they said no bail, or I didn't see, it might be so, Your Worship. I did not see the consultation on TV that one of the public members requested to be kept in custody. As a matter of fact, Your Worship, the Worship can take in consideration almost in all high-profile cases and cases there where the public is always unsatisfactory precept by the public, Your Worship, they request the offenders or accused persons at that stage who is charged with the offences, Your Worship, to be kept in custody. Your Worship, it's my humble submission, taking in consideration all the aspects that I've referred the court to, and to consider, Your Worship, that it will be in the interest of justice to grant bail to the first applicant, Your Worship, with such conditions that the court may deem fit, Your Worship. As I already indicated, Your Worship, the first applicant is in the position to pay bail in the amount of, to gather money for her family and friends in the amount of 10,000 rand. If the court favourably consider bail for the first applicant, Your Worship, I request the court, and if the court is of the view that the amount of 10,000 rand is not enough, Your Worship, I request the court not to set an amount of bail that is so high that it will boils down to the fact of the mere fact that the first applicant will be denied bail. If you have anything else the court would like to hear me on, Your Worship, I'll address the court. Otherwise, I'll stand with my address.
Thank you, sir.
Thank you, Your Worship.
Mr. Fintel.
Thank you, Your Worship. Your Worship, I am not going to repeat what my learned friend said concerning the criticism against the investigating officer's testimony, as I concur with that, and in order not to burden the court with duplication of matters, it also stands for the address of my learned friend, the prosecutor, in her address to court, in which clearly matters were introduced that was not based on the evidence submitted to the court. I concur with my learned friend as far as that is concerned. I will address the court briefly on what I regard as the principles that has crystallized in our law concerning bail applications, and then with reference to one decided case of which I have made a copy for the convenience of the court, and which, if the, with the consent of the court, I will hand up and refer to it when we get to the point. Your Worship, very briefly, the default position in our law currently regarding the granting of bail in the instance of a Schedule 1 crime is, in terms of Section 61A of the Criminal Procedure Act, the accused is entitled to be released on bail at any stage during the proceedings, except if the interest of justice indicates otherwise. I respectfully submit that it's the duty of the court to strike a balance between personal freedom of the accused and the public interest. Further, the onus, as already stated, is on the state to prove that detaining the accused is in the public interest, and that must be done on a balance of probabilities. This is not a trial, and the court is not required and should not make a provisional finding of guilt. That is the exclusive duty of the trial court. The court is to address the prima facie strengths or weakness of the state case, but the central question remains whether the accused will stand her trial. The accused does not need to give oral evidence, as the evidence given by the accused will be admissible during the trial. The essence of the principles and considerations underlining bail is that no one should remain locked up without good reason. The interest of justice is still in favor of protecting the freedom of the citizen rather than depriving her or him of that freedom. The reasons for refusing bail can usually be found in one of two considerations or both, and that is, one, will the accused abscond, and will the granting of bail lead to the interference with the investigation or prosecution? That is normally the case. My submission with respect is that the state is relying on a third aspect, and that is the reaction of the public, which I will address a little bit later, which is part of this campaign against abuse against women and children. In considering the risk or possibility that one or more of the consequences mentioned in subsection 4 will result, the court cannot speculate. Evidence must be submitted and a finding on the probabilities must be made unless it is found that one or more of the consequences will probably occur. The detention of the accused is not in the interest of justice. The following are to be considered: flight risk. Bail is only to be refused where there is a real danger that the accused will not stand trial. Factors that may indicate such a risk are the gravity of the charges, the possible sentence, potential mobility of the accused, the passport, ability to cross the border, and possible asylum. And this, Your Worship, is my submission that the witness called by the state has not supplied sufficient proof to confirm that there is a possibility of flight. And this can all be eliminated by imposing proper conditions for the bail if the application is approved. Interference with witnesses or evidence, a real danger must be indicated. No indication was given in this instance. A fear was expressed, not substantiated. There's no indication that it happened as far as accused or any of the accused are concerned in previous cases. And well-grounded fears must exist. In this case, the investigation is almost completed. Formal evidence is still gathered, and in the meantime, accused or the fourth suspect has been arrested. Also, which are to be taken into consideration in this instance is the conduct of the accused. And the witness for the state clearly testified that she cooperated in all respects once she was confronted. And again, this danger could also be eliminated by imposing proper conditions or appropriate conditions. And the onus on the state is to show that the accused would indeed attempt to influence or intimidate state witnesses. Undermining of justice, section 68, risk of further offences. Your Worship, it was stated by the investigating officer that she's done it once, she can do it again. Your Worship, that is so improbable that I don't think it deserves an argument. She is 40 years old, a first offender, and there is no indication at all of that possibility or that such a likelihood exists. Public peace and security, Your Worship, this is the ground on which the state heavily relies, and it is clearly stated in this section that it's only to be applied in exceptional circumstances as it pertains not to the conduct of the accused but of other persons. This factor concerns public order, peace and security, and not a mere discontent and unpopularity. Your Worship, in this regard, I would like to refer the court to the matter of Nell and others versus the state, of which a copy was handed up to the court. Unfortunately, Your Worship, the printed case, the pages were not numbered. I've taken the liberty to number them in order to make it easier for the court to follow my references to the particular case.
Yes, thank you, Mr.
Your Worship, briefly, this case was an appeal to the High Court in Johannesburg against the refusal of bail on a charge of attempted murder or alternatively assault with the intent to do grievously bodily harm. What was in dispute was whether it was a Schedule 5 and who bears the onus to prove that the interest of justice will not be impaired. That is not really relevant for our purposes today, and that continue until page 8 of the case that I refer to. What is important is paragraph 13. The paragraphs are numbered on the left-hand side, and indeed this portion where the court finds that this court has the benefit of the evidence and submissions relevant to the attempted murder charge, both prior to the issue of the ruling and the conclusion of the evidence. This court is therefore in a position to determine the issues in this appeal and to give the decision which the lower court should have given. In other words, the Court of Appeal was in possession of all the evidence and arguments. I then refer the court to page 9 at the bottom, paragraph 16. For purposes of this appeal, the remainder of the grounds of appeal and heads of argument clearly move from the premise that the appellants had adduced evidence in balance of probabilities in satisfying the onus brought about by section 6 in brackets 11 in brackets B. In other words, the onus was in this instance on the applicants to prove. Your Worship, and then in paragraph 17, the following is stated: I propose to approach the appeal on the basis of these grounds of appeal. The magistrate in effect refused bail by finding a likelihood on the ground set out in section 60 in brackets 4 in brackets A, B and C and E, read with the factors of section 60 in brackets 5, 6, 7 and 8A of the Criminal Procedure Act. Paragraph 18. Before proceeding to deal with the grounds of appeal, it is clear that the personal circumstances of the applicants were not placed seriously in issue at the bail application and not disputed by the investigating officer. I therefore do not propose to repeat the personal circumstances, and I will return to the personal circumstances of accused number 2. And then on page 11, the middle of the page, the learned judge referred to the evidence of the 2 policemen and judging the value thereof. The important part is from the middle of the page, the finding lost sight of the evidence of Constable Claudia and Warrant Officer Naidu on the cross-examination that the fear expressed by the complainants and witnesses was premised on what might happen if the appellants were released on bail. The appellants in their affidavits indicated that they would not interfere with or intimidate state witnesses. What is required is a likelihood of the offending behavior manifested itself and not a mere possibility. The gravity and seriousness of the offence cannot be overlooked, which was at face value brutal, but in itself cannot lead to a conclusion that witnesses would be intimidated. The imposition of suitable bail conditions was overlooked. I have already referred to that. Then further on page 12, Your Worship, the flight risk is addressed. It's the third paragraph from the top. The magistrate found that the first appellant had surrendered himself merely on the basis that the accused 4 had been released on bail, anticipating that he too would be released on bail. This led to a finding that the first appellant was a flight risk. There were no objective facts before the magistrate to draw this inference. The third appellant, the magistrate found, posed a flight risk based on the strengths of the state case and the likely sentence that would be imposed in the event of a conviction. The finding lost sight of Constable Claudi's evidence during cross-examination that the third appellant would not flee. An accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused unless this is likely to prejudice the ends of justice. This is from a case cited by the judge, S versus Atchison. The reference is contained in the document in the case. Then at the bottom, Section 64C is handled with: the interest of justice do not permit the release from detention where there is the likelihood that the accused, if he or she were released on bail, will attempt to influence witnesses or to conceal or destroy evidence. In this instance, Your Worship, there is a reference to a counsel who visited the hospital where one of the accused, one of the complainants or witnesses were treated, and the judge find that that cannot be construed as an act on behalf on the part of the applicant and, although not proper, are not to be considered. Then at the bottom of page 13, we turn to the factor that the state is heavily relying on, and that is where in exceptional circumstances there is the likelihood that the release of the accused will disturb the public order or undermine the public peace and security. On the top of page 14, Section 8A, in considering whether the ground in subsection 4E has been established, the court may, where applicable, taken into account the following factors, namely, whether the nature of the offence or the circumstances under which the offence was committed is likely to induce a sense of shock or outrage in the community where the offence was committed, whether the shock or outrage of the community might lead to public disorder if the accused is released, whether the safety of the accused might be jeopardized, whether the sense of peace and security among members of the public will be undermined or jeopardized by the release of the accused, whether the release of the accused will undermine or jeopardize the public confidence in the criminal justice. The approach on this ground was settled in the matter of S versus Limini, which is referred to on the same page, 1999, ZACC 8, reported in Bundle 2, 1999, SACR on page 51, where the Honourable Judge Kriegler held as follows. It is important to note that subsection 4E expressly postulates that it is to come into party only in exceptional circumstances. This is a clear pointer that this unusual category of factors is to be taken into account only in those rare cases where it's really justified. What is more, subsection 4E also expressly stipulates that finding of such circumstances has to be established on the preponderance of probabilities, likelihood. Lastly, once the existence of such circumstances has been established, paragraph E must still be weighed against the considerations enumerated in subsection 9 before a decision to refuse bail can be taken. Having regard to these jurisdictional prerequisites, the field of application for subsection 4E and 8A will be extremely limited. Judicial officers will therefore rely on this ground with great circumspection in the knowledge that the Constitution protects the liberty interest of all. And then finally, Your Worship, this case also refers to the interest of the press in this particular matter, and that is addressed by the court on page 18.
Sorry, Mr.
The top paragraph.
Page 18.
Page 16, I apologize, sorry, Your Worship. The top paragraph, the magistrate appears clearly to have been influenced by the events which manifested itself in the social media, comments emanating from the Minister of Police on Twitter, and protesters who had gathered opposing the release of the accused on bail. On what public outcry constitutes, the magistrate indicated that she did not need a dictionary to tell her what public outcry was, but had merely to have regard to section 68A. It is apparent that the magistrate paid lip service to the statutory provision. And finally, at the bottom of page 16, paragraph 26, this is what the court need to take into consideration with respect. Upon a consideration of the totality of the factors set out in section 68A, it is clear that they are not to be read individually but jointly, the one following upon the other. Whilst the court notes that there were protests of bail to be refused, that there has been an outcry on social media, the question remains. Even though the magistrate had found the likelihood that the release of the Appellants would disturb the public order or undermine public peace and security, Whether a consideration of Section 69 could have mitigated this aspect, the magistrate failed to consider the provision of this section, which on its own is a material misdirection. That deals, Your Worship, with the interest of the social media in this matter, and it is my humble submission that this interest should not be confused with the public interest. It is my contention that the public has the right to know what's happening, what was the outcome thereof, and we are not to be influenced by the huge publicity that this matter is getting at the moment. And as been said to the court already, that has faded. There's nothing of it today except the interest of the press present in court. The court is not even full to capacity anymore. Your Worship, based on this, it is my submission that there's nothing been adduced by the state that prevents accused number 2 from being granted bail. And should there be, it can all be addressed by the proper conditions being set for the granting of bail. And my instructions are that an amount of 10,000 rand is available should the court grant bail. If there's anything else the court would like to hear me on, I would address the court. But this is my argument.
Thank you, Mr. Venter.
Thank you.
Mr. Chirwa.
Thank you, Your Worship. May I proceed, Your Worship?
Please do.
Thank you, Your Worship. Your Worship, we are here today to deliberate on the release of the accused persons, Your Worship, on bail. Now, Your Worship, in consideration of such, Your Worship, the court is guided by the provisions of Section 60 of the Criminal Procedure Act. Now, Your Worship, before I continue, or rather proceed with my address on these merits, Your Worship, I would like to applaud the state on their brilliant argument, Your Worship, that they've presented before this honorable court. However, in the very same breath, I will outline or highlight, Your Worship, that this argument was premature, Your Worship, as this argument should have been saved for the trial. The court, Your Worship, was present when the investigating officer testified as to why bail is opposed. Now, Your Worship, when the state argued before this honorable court as to why this bail should be opposed, Your Worship, their argument relied heavily on how strong the state's case is, Your Worship. Their argument relied heavily on how the accused persons will be found guilty in the court of law. Their arguments, Your Worship, relied heavily on how the public feels about the matter that the accused persons are facing before court. However, Your Worship, they have failed to correctly, Your Worship, identify the provisions that are outlined in Section 64, Subsection A to E, Your Worship. At some stage, Your Worship, even myself, I was confused as whether we are here before this court for a trial or a bail application, Your Worship. It is common cause, Your Worship, that a bail application is not a dress rehearsal for the trial. What this court, Your Worship, is tasked to deal with versus what the trial court is tasked to deal with are two separate things, Your Worship. This court is dealing with the bail application of the accused persons, a Schedule 1 bail application, Your Worship. This court is tasked with establishing whether these accused persons, Your Worship, if they are released on bail, will they come back to court? If they are released on bail, will they attend all other further processes from that emanate from the court, Your Worship? Now, Your Worship, let's go to the evidence of the investigating officer, Your Worship. The investigating officer, Your Worship, testified to a very lengthy extent as to how strong the state's case is. And perhaps, Your Worship, rightfully so. However, Your Worship, he has failed to execute the mandate, Your Worship, that was put on him, Your Worship, to advance credible reasons, Your Worship, as to why the accused persons should not be released on bail. As I've outlined, Your Worship, or rather I've mentioned, this is a Schedule 1 bail application. The onus, Your Worship, clearly is placed on the state that they should prove that it is not in the interest of justice to release these accused persons. In this honorable court, Your Worship, bail applications are brought as per the schedule that the matter falls under. This court, Your Worship, is dealing with a Schedule 1 bail application. As I've mentioned, that the onus is on the state to establish whether interest of justice permit or not. In a Schedule 5 bail application, Your Worship, that onus is shifted to the applicants to deduce evidence that it is in the interest of justice that they are released on bail. To go further, Your Worship, in a Schedule 6 bail application, the onus is also placed on the applicants that they should deduce evidence that exceptional circumstances exist that the interest of justice permit their release on bail, Your Worship. The state in this matter, Your Worship, has incorrectly treated this bail application as if it's a Schedule 6 bail application, Your Worship. That the defense counsels of applicants, Your Worship, have to argue to such an extent as if we have to provide exceptional circumstances to this honorable court, Your Worship, as to why the accused persons should be released on bail. That is not what we're here for, Your Worship. What we are here for, Your Worship, is to challenge what the investigating officer should have testified on as to why the bail should be opposed. And, Your Worship, the issue that I have with what the investigating officer testified is that, if not all of his evidence, Your Worship, it was speculatory in nature. No concrete evidence was advanced as to the reasons that he advanced as to why he's opposing the bail, Your Worship. And without endeavoring to argue semantics, Your Worship, in this matter, the use of the word might, possibility, was used at great length by the investigating officer, Your Worship. Now, as I've said, Your Worship, I'm not trying to argue semantics. However, Your Worship, as officers of the law and of the court, there is a clear distinction between likelihood and possibility. The legislator, when outlining the provisions of Section 64, A to E, refer to the use of the word likelihood. And there is a reason that this word likelihood was not used interchangeably with possibility. Now, as I've mentioned, Your Worship, the IO's testimony, they relied on the fact that it's a possibility that the accused persons might interfere with witnesses. It's a possibility that the applicants might evade trial. It's a possibility that their release on bail will undermine the proper functioning of the justice system. This is not what the legislator required, Your Worship, when these provisions were formulated. It required that there must be a likelihood, Your Worship. And if I may refer to how it is defined, Your Worship, in the dictionary. Possibility, Your Worship, is defined as a thing that may happen or be the case. Likelihood is defined as the state or fact of something being likely, a probability. Therefore, Your Worship, this honorable court, Your Worship, we are not here to speculate as to what might happen or might possibly happen. This is a court of law. It deals with facts. facts must be advanced to the court, Your Worship, as to why they are saying that this will or may happen. As much as, Your Worship, these accused persons or these applicants, and specifically applicant number 3, appearing before a court of law, Your Worship, Section 35 of the Constitution, Your Worship, should be considered. We are not here, Your Worship, to establish their guilt. We are here to establish whether, if released on bail, they will not impede on the provisions outlined in Section 64 to A to E. Therefore, Your Worship, they still enjoy the right to be presumed innocent until proven guilty. And I will refer, Your Worship, to certain points in the handout that was handed to the court by my learned colleague, Mr. Fente, Your Worship. Section 64 to A, Your Worship. And I'm not trying to be repetitive, Your Worship. I just want to stress certain outlines.
Are you now referring to the same case?
Indeed, Your Worship.
Yes, sir.
Section 64A to E provides that the interest of justice do not permit...
Where are you now?
Your Worship, my one is not numbered, but I'm on where paragraph 19 begins, Your Worship. If the court can just find paragraph 19,
Yes.
and I'll start referring from there going forward, Your Worship. May I proceed, Your Worship?
Yes, page 10.
Yes, Your Worship. Section 64 to A provides that the interests of justice do not permit the release from detention of an accused person where there is a likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any particular person, or will commit a Schedule 1 offense, Your Worship. As I've outlined the difference between likelihood and possibility, Your Worship, it is also referred to in here, that what is required is a likelihood of the offending behavior manifesting itself, and not a mere possibility, Your Worship. Your Worship, this court is dealing with the freedom of liberty and the freedom of the accused persons, Your Worship, and such freedom cannot be restricted and limited, Your Worship, due to mere possibilities, Your Worship. And the mere fact, Your Worship, that this bail application is televised, Your Worship, should not deviate from the fact that it is still a bail application, Your Worship. And what I mean by that, Your Worship, is that we are here, Your Worship, to argue on points of law and not trial by media, Your Worship. The media is just simply here, Your Worship, to show what the outcome was, Your Worship, and not to sway the decision that must be taken today, Your Worship. If the court is satisfied that the state has proved that it will not be in the interest of justice that the accused persons be released on bail, then the court has the discretion, Your Worship, to deny bail in this matter. However, in the very same breath, Your Worship, if the court is satisfied that the state has failed, Your Worship, to show that it is not in the interest of justice that they be released, then bail should be granted, Your Worship. And the mere presence of the media, Your Worship, should not sway such decision. I'll refer to the next page, Your Worship, where it refers to Section 64B, Your Worship. May I proceed, Your Worship?
Yes, please.
The interests of justice do not permit the release from detention of an accused, again, Your Worship, where there is a likelihood that the accused, if or he or she were released on bail, will attempt to evade his or her trial. And I'll refer to the fourth paragraph on that page, Your Worship, where it says, an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. Your Worship, I want to stress this point. In conjunction with Section 35 of the Constitution, Your Worship, all accused persons that come before court enjoy the right to be presumed innocent until proven guilty, Your Worship. And the refusal of bail should not act, Your Worship, as a way to punish them in anticipation or rather in preempting that these people will be found guilty. that is the job of the trial court, Your Worship. The trial court will make a decision with the evidence that is presented before it, that the accused persons before court indeed are guilty, Your Worship. And it further says, Your Worship, the court will therefore ordinarily grant bail to an accused unless there is a likely to prejudice the ends of justice. In this case, Your Worship, I do not believe there is a likelihood to prejudice the ends of justice. The investigating officer has testified that his investigations are virtually complete. The state, Your Worship, in their arguments also mentioned that whatever witnesses that the state intends on calling, they've made statements, Your Worship. And it is tried law that witnesses who have made statements, Your Worship, by virtue of those statements now have become compellable witnesses, Your Worship. And the mere fact that the state is saying that if these accused persons are released on bail, Your Worship, they might influence these witnesses not to come testify. How can you influence a witness not to testify when they have made a statement and they've become a compellable witness of the court, Your Worship? They can be compelled to testify, Your Worship. And it cannot just be said that they might influence these witnesses, Your Worship. Now, with relation to accused number 3, which is applicant number 3 in this matter, Your Worship, the state alluded to the fact that accused number 3 is also linked through a pointing out. This was tested, Your Worship, as when the investigating officer testified. And it has become common cause, Your Worship, that such pointing out was made before the accused person had obtained legal representation. Even though, Your Worship, the investigating officer alluded to the fact that a certain document was complied with and was filled, which addressed the issue of legal representation. However, Your Worship, pointing out the very same way with confessions have certain requirements that have to be met, Your Worship. And should this matter proceed on trial, such pointing out, Your Worship, can be challenged in the trial court. Now, Your Worship, if the investigating officer is going to preempt the guilt of the accused person on this mere pointing out, he is not giving consideration to what might occur in the trial court, Your Worship. Which further supports my submission, Your Worship, that this court, Your Worship, is not tasked with determining whether these accused persons have committed this offense or not. We accept the investigating officer saying that the state's case is strong. However, Your Worship, it's a bail application. I want to stress this, Your Worship, it's a bail application. We deal with whether the accused persons will come to court, whether they will be found, Your Worship. With regards to accused number 3, the state relies on the fact that he sold his property. And it's just unfortunate that the sale of this property went through around the same time that he was arrested. The investigating officer testified that the sale of the property was instituted in June. However, the person who sold his property informed his legal representative that the sale was instituted in February, Your Worship. Now, who does the court believe? The investigating officer or the person who instituted the sale? Secondly, the investigating officer testified that, I think it was on the 4th of September, they went to visit the accused residence, where they did not find him there. They found bags that were packed. Of course, they were going to find bags that were packed. He had to vacate those premises. And at that stage, there was no legal duty or legal obligation for him to be found at his house, Your Worship, at that stage, as he was not an accused person before this honorable court. And subsequent to the sale of this house, Your Worship, he has provided an address that he will be most likely staying should this court release him on bail. Now, the investigating officer came and testified, Your Worship, that he went to visit that address. And he spoke to the alleged owner of the property, Your Worship. Now, my issue with his visit to that address, Your Worship, and this was also posed to him under cross-examination, was whether his visit was to identify that address as an alternative one or to further his investigations. He considered that it was to further his investigations. And upon discovery of such information, Your Worship, I endeavored to contact the daughter of the accused, Your Worship, to inquire specifically about what this visit was about, Your Worship. And she also confirmed that the investigating officer was there to conduct further investigations on the matter. And that at no stage he inquired about that address being suitable for the accused person to stay there, Your Worship. Which further proves the submissions by my learned colleagues, Your Worship, that the investigating officer is opposing the release of the accused persons on bail due to these own fears that he might have, Your Worship. And Your Worship, lastly, mention was made about a Nigerian guy that is owed certain funds. Further mentioned was that this Nigerian guy is still out there wanting his money. How this is not speculation, Your Worship, I do not know. As there is no concrete evidence, Your Worship, to that effect. The state also argued that the accused persons themselves will also be in danger. What is this danger that they are referring to? Are they then not promoting acts of crime that could be committed against them, Your Worship? The Constitution does not only protect it does not only protect some, it protects all, accused or not, inmate or not, black, white, male, female, adult, child, it protects all, Your Worship. And that is why even persons who are charged with allegedly committing a certain offense have certain rights that they enjoy in terms of Section 35, Your Worship. And this apparent danger that the accused persons are facing should not outweigh the right to freedom that the accused person have, which is enshrined in the Constitution. Therefore, Your Worship, in closing, we are of the belief that the state, Your Worship, has dismally failed to produce that it is not in the interest of justice that the accused person be released. And I'm of the strong opinion, Your Worship, that this court should grant bail, and in granting bail, Your Worship, the accused person, or applicant number 3, has outlined how much he can afford, Your Worship. However, we are not restricting the court to that amount. The court can decide whatever amount that it will deem suitable. However, Your Worship, we'll just make one plea to the court. That the court should be of the opinion that bail should be granted in this matter. When considering a suitable bail amount, Your Worship, the court should consider the personal circumstances of the accused persons individually, Your Worship, in relation to how much they can afford, Your Worship. And when setting such a bail amount, Your Worship, it should not endeavor to set a bail amount, Your Worship, that will result in the indirect refusal of bail, Your Worship, because if the court sets an exorbitant amount, Your Worship, it will defeat the purpose of why we are here today, Your Worship. The accused person will remain in custody. And if the court, Your Worship, requires further submissions from the defense, that will be the submissions in respect of applicant number 3, Your Worship. Court, please.
Thank you, Mr. Chirwa.
Right, on conclusion of the evidence, testimony, arguments and submissions made in this matter on behalf of both the state as well as the applicants in the matter, the different arguments and the separate arguments made by the prosecutor as well as the 3 different arguments made by the respective legal representatives, the court is now tasked with the responsibility and the onus of processing same, dissecting same, and in reaching a suitable conclusion of whether or not the interest of justice indeed permits the release of the applicants on bail. And whether the applicants 1, 2, and 3 are then suitable candidates to be granted bail in an amount to be fixed and determined by the court. Without preempting such deliberation and or judgment, the court will simply, for purposes of the record and for the benefit of the large public interest in the matter, record the following. Firstly, the application concluded today is an application by the applicants 1, 2, and 3 to be released from detention or custody and be granted bail as stated in an amount to be determined. As the application falls within, as was correctly pointed out, which is not in dispute, a Schedule 1 bail application, the state bears the onus of proving that indeed the interests of justice do not permit the release of the applicants on bail, as it is the state that is opposing the release of the applicants on bail. It must also be noted that as South Africa is a constitutional state, this court, just like every other court, higher and or lower court in the Republic of South Africa, is bound by the prescripts and the provisions of the Constitution of the Republic of South Africa, that is the Constitution 108 of 1996. More specifically, the court is bound to take into account the provisions of the Bill of Rights as contained in Chapter 2 of the Constitution. In terms of same, and in terms of the provisions of the Criminal Procedure Act, which is Act 51 of 1977 as amended, the applicants before the court appear as the accused before the court. And just like every other accused persons, as they have indicated in their respective applications, that each one of them intend to plead not guilty to the charges against them, they are then presumed to be innocent until they have been found guilty in a court of law. That court of law, as was correctly argued, is a trial court, where the evidentiary burden, while still resting on the state or the prosecuting authority to prove the guilt of each of the accused, however, such burden of proof changes to the guilt of the accused beyond reasonable doubt. That is then the function of the trial court. This court, sitting as the bail court, as we have just concluded the proceedings, must ensure, as was correctly argued as well, that bail proceedings do not degenerate into a trial and or a protracted trial, and or even, as was correctly pointed out by Mr. Chirwa here, a dress rehearsal for a trial. This is trite. The bail court, as in this application, is simply tasked with weighing the interests of justice against the personal freedom of each of the applicants sitting before the court. And until such time as the guilt and or innocence of the applicants is or proven in a trial court, the court is now burdened with a careful and considerate calculation and reconciliation of the extensive testimony, evidence, submissions, as well as the lengthy arguments as presented today during the course of the proceedings, which spanned some now 2.5 days, in arriving at a fair, value-based judgment. Together therewith, the court is also tasked then with the consideration of the constitutional provisions as well as the relevant provisions relating to bail as per the Criminal Procedure Act, as per the law. The court will, as it often does, and in affording fairness to each of the respective parties before the court, including the prosecution as well as the respective applicants 1, 2, and 3, bearing obviously in mind that bail proceedings are inherently urgent in nature, the court will now apply its mind to the matter and in arriving at a judgment. And as the court, or specifically myself, as I am not available for the next 3 days, we will postpone the matter then for judgment only in respect of this application to 11 October 2019, if that is obviously suitable to the legal representatives.
It will suit me.
All right, thank you. Mr. May.
I will arrange my diary accordingly, Your Worship.
Thank you. That is only then for judgment in the matter.
Yes, thank you, Your Worship.
Mr. Chirwa, I know that you are unavailable.
Indeed, Your Worship.
Obviously, your office will send somebody just to note the judgment.
I believe it will, Your Worship. However, my concern is that it's a Friday, and usually the office will send someone for my court days, which are Monday to Thursday. However, Your Worship, in the sense of the urgency of this matter, Your Worship, I will try to make arrangements for someone to be sent to note the judgment on the day, Your Worship, of the 11th.
Yes. So that date is suitable to you as well.
I believe it's suitable.
All right, thank you. The matter, Ms. Human, Ms. Nell, and Mr. Van Zyl. This matter, on conclusion of the evidence, testimony, submissions, etc., before the court, on conclusion of the bail application, the matter then will be postponed to 11 October 2019. That is for judgment only in the matter. Right? You are all three then remanded back into custody, and you are all three to remain in custody until then. Thank you.
Court, please, Your Worship.
As the court pleases, Your Worship.
Thank you, sir. Ms. Ngobo.
That
Any-
will conclude our Your Worship.